arms is unconstitutional. In the case of Heller versus District of Columbia, the Supreme Court recognized that the Second Amendment protects an individual right to keep and bear arms, and that an important part of that right is to protect the ability to defend yourself. More recently, just a few years ago, in the case of Bruin versus New York Rifle and Pistol Association, the Supreme Court held that if the government does want to pass laws that restrict the rights of the people to keep and bear arms, it may only do so if the government is required to later prove in court that that law is consistent with our nation's historical traditions with regard to regulating guns.
Well, let me ask you about Bruin. And I briefly looked at it, but I copied some portions of it. One of them says, after doing the historical survey, that the New York law effectively, quote, prevents its law-abiding residents from carrying a gun for this purpose, end quote. And so how do you take a law that prohibits law-abiding residents from carrying a gun and make it applicable to convicted felon drug offenders?
Well, for one thing, just the fact that someone has been less than law-abiding in the past doesn't necessarily mean they're not law-abiding now. You can, I would say, the important thing would be to look at, are you law-abiding in terms of, are you out assaulting people with that gun versus are you protecting yourself?
I don't know, but I would think statistically that would be the best way to make that determination.
Well, I guess what I'm saying is, if I'm out looking for people to rob, I'm not law-abiding. But if I'm out just on the town and I'm worried about people robbing me, then even if I've done bad things years in the past, I could still be law-abiding now. In any event, in Rahimi,
even if you have a history of significant drug charges and prior possession of weapon charges?
Even so, Your Honor, I would say if you've been law-abiding, if you're law-abiding now, that's what they were, I submit, primarily talking about. But regardless, in Rahimi, they basically backed away from that whole law-abiding, responsible citizen language. And so I submit that that's no longer really the test.
Okay, I thought that's
to
what you were arguing,
to whatever extent it was ever meant to be the test. But if we are going to talk about law-abiding, I would just submit that, you know, I don't have a right to carry a gun around if I'm on my way to go murder someone, I would submit. But if I'm not doing that, if I'm out doing things that are perfectly legitimate, even if I committed a drug crime or whatever other crime 10 years before, that doesn't mean that I'm not law-abiding now.
So your argument goes to all convicted felons, even though this is specifically a felon drug offender, right?
I mean, it would be outside the scope of this appeal to address all convicted felons. My personal inclination would be to say that all these same arguments should apply to all felons, but for purposes of this appeal, this court only has jurisdiction to talk about drug felons.
Hasn't the Sixth Circuit addressed this issue already in Tennessee?
The Sixth Circuit has, I don't know that it was specifically for Tennessee, but yes, the Sixth Circuit has addressed this issue, and it, in theory, could apply if someone were to sue over it in Tennessee.
It was the Eric Williams case?
Yes, Your Honor.
That was out of Memphis.
And the state, in my appeal, has, on some level, I submit, conceded that our law is unconstitutional. Basically, the state here says that if the drug felon isn't dangerous, then he does have a right to bear arms, regardless of what the statute says. However, the state...
they say that in their brief?
Basically, yes, Your Honor. But the caveat that they give, and the reason they still say Mr. Russell should lose, is they say, well, you don't have a right to have a jury decide whether you're dangerous. And in fact, you don't have a right to make the government prove at all that you're dangerous. Instead, you have to prove you're not dangerous, and you have to prove it to a judge rather than a jury. And my response to that is, one, it violates due process to flip around the burden of proof. Two, it violates your right to a jury to make you prove it to a judge rather than a jury. And three, maybe most importantly, it violates the separation of powers for us to sort of create this hypothetical law that doesn't really exist. The law as it exists doesn't make any kind of an exception for whether you're dangerous now versus non-dangerous. It just says if you've ever been convicted of a drug felony, you're not allowed to keep or bear arms. And so, consistent with what the law actually says as written here, the trial judge in Mr. Russell's case, he didn't look at, he just looked at the law. He didn't believe that he had any kind of power to make any kind of determination about, well, whether Mr. Russell is dangerous or not or anything like that. He just, or to make any kind of individual determination. He just looked at the law and said, you're a drug felon. The legislature has said drug felons are dangerous, and therefore I find you, you know.
Didn't the trial judge reference, I mean, I know there's not a whole lot in the record, but there was a notice of, prior crimes for impeachment, which included a significant chunk of drug felonies and, like I mentioned earlier, another possession of a weapon by a convicted felon. Didn't the trial court reference those things in its ruling?
I don't know to what extent he referenced them, but I don't disagree that those are in the record. We had the defendant come in and testify about his record, and then the state filed a late filed exhibit where he produced the specific.
And what was his testimony about his record? What did he have to say about his criminal history?
He just said he had a prior drug convictions, had no prior violent convictions, no murders, no assaults, no rapes, no robberies. And then he did have the prior drug charges. I think he didn't seem to remember whether he even had a prior gun charge, but
I think the record proved that he did.
The record shows that he did, yes, ma'am.
Are you saying that only murders, rapes, only those types of crimes are those which, after conviction, we can prohibit gun possession?
Well, here's the deal. As I've said, I'm not really here to debate whether violent convictions should take away your right to keep and bear arms, because that's outside the scope of this appeal. My personal inclination is to say no, they should not. But we could debate all day long, could the legislature pass some different law that said if the jury finds that you're presently dangerous and you have a drug felony or whatever other felony, is that constitutional to keep you from bearing arms? I submit it's beside the point, because that's not what the law, I submit the answer is probably no, because such a law, I contend, would still not be consistent with any laws that existed in the 1700s or early 1800s. But the fact of the matter is the legislature hasn't passed that law, and so basically the state is trying to defend a law that might be more constitutional than what we have, maybe, but maybe not, but that regardless, it's a law that just doesn't exist. They're defending a non-existent law and effectively conceding that the law we have has major problems. In terms of the actual test the court is required to apply, it's supposed to look at basically the way the laws were in the 1700s or maybe the early 1800s, and basically decide, well, is it, back then, did they have laws banning felons from owning firearms or anything
Well,
similar?
this country has a history of prohibiting some people from possession of weapons, people who are considered dangerous. I know that's not a term that we're defining now, but do you disagree with that?
I do basically disagree with that. In terms of barring felons specifically, that it wasn't until like the 1930s that anywhere started doing that. And in Tennessee, I don't believe it was until 2009. In terms of barring other dangerous people, the state obviously, they can't point to any laws to start saying that felons were prohibited back in the 1700s from owning guns, because there weren't any such laws. There weren't any laws permanently disarming felons or any other criminals. And frankly, selling drugs back then wasn't a felony or probably any crime at all. Even the crime that would be most comparable to it, smuggling, was usually not a felony, as I pointed out, citing William Blackstone. So the state can't point to any comparable law along those lines. Instead, At the trial level, the state tried arguing, well, all felons were put to death, and so we never had to decide this issue. In my brief, I've cited some authorities saying that that's not really true. Felons typically weren't put to death. Most felons were not put to death. Much like today, most felons are not put to death. And even if they were, the fact that when I die, I don't lose my rights. I'm just not able to exercise them anymore because I'm no longer alive. But the fact that I'm no longer, that practical effect of dying can hardly excuse us from taking rights away from the living. The living are the ones who need to protect themselves when they're out on the town and they encounter dangerous individuals. And if we look at what the Supreme Court said in Bruin, they talked about how we've always had dangerous people, we've always had felons, but in Bruin they said that many firearm regulations seek to address general societal problems that have persisted since the founding. And they said in these instances the inquiry is fairly straightforward in terms of how to apply the Second Amendment. The absence of a distinctly similar historical regulation addressing the problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. So if we've always had felons, even in the 1700s, but we didn't used to disarm them, instead we put the worst of the worst to death, similar to how we do today, that is evidence that the challenged regulation today of disarming all felons is inconsistent with the Second Amendment. In Bruin, they said, if earlier generations addressed the societal problem but did so through a materially different means, that too is evidence that a modern regulation is unconstitutional. So before, if they would put the actual really dangerous people to death, that's a materially different means from disarming permanently all felons. Now, unable to point to any...
You say permanently. Isn't there a procedure for convicted felons to get the right to carry or possess a weapon?
I would say definitely not for Mr. Russell. I think the state did point to some examples of if you have certain types of drug felonies, if you have only one of them, I think they said you can get that expunged. For the most part, I would say no, Your Honor. Okay. Other than maybe getting I think there's a pretty good argument if you get a governor's pardon, then that can restore your rights. So on appeal, as far as I can tell, the state has abandoned the whole argument about putting all felons to death. And instead, on appeal, the state just points to examples of, well, we used to discriminate against these different people. We used to discriminate against blacks, whether they were free or unfree. We used to discriminate against Catholics. We used to discriminate against Indians. And the key thing to focus on with regard to that argument is that the text of our law today is substantially different from what it was prior to the Revolution. Prior to the Revolution, there was the English Bill of Rights, and it specifically said Catholics don't have the right to keep and bear arms. It said the subjects which are Protestants may have arms for their defense suitable to their conditions and as allowed by law. And so that's why in the most recent Supreme Court case of Rahimi, the court explained that by the time of the founding, state constitutions and the Second Amendment had largely eliminated governmental authority to disarm political opponents on this side of the Atlantic. Basically, prior to the Second Amendment, these groups that the state is talking about, how we used to discriminate against them and disarm them, those people were not considered full citizens of society. They weren't considered full parts of the people. Whereas in the Second Amendment, we passed this new law that clarified things and expanded things somewhat, and it said, the right of the people to keep and bear arms shall not be infringed. And so we're not allowed to discriminate against blacks anymore because they're part of the people. We're not allowed to discriminate against Catholics anymore. We're not allowed to discriminate against Indians anymore insofar as they're now part of the United States. And that's just a key difference in the law. And so the fact that those outsiders who are not part of the people were sometimes disarmed should have no bearing on whether we can now disarm Mr. Russell, who is undisputedly part of the people.
Well, since we've had historically the right to change legally what the people are, to allow blacks and Catholics to be part of the people, doesn't the legislature therefore have the right to decide who is not the people, and by doing that, put convicted drug felons in that group?
I don't believe so, Your Honor. I believe that the Bruin case and pretty much the case law is universal, that Mr. Russell is considered part of the people, and that therefore the Bruin test applies, which is that we have to look at whether the people could historically be regulated in this way. So my time is up. I will come back for rebuttal.
General Groves?
Good morning, Your Honors. Alan Groves on behalf of the state. So just to put this case into perspective, the defendant is really asking this court to be the first court in the nation to hold that a law disarming drug felons facially violates the Second Amendment. That's what he's asking this court to do, but there are at least two good reasons not to do so, as the trial court properly held below. First, something my friend on the other side has not mentioned yet this morning, the Supreme Court has repeatedly said that felon in possession laws are presumptively lawful. And second, even if we are applying Bruin's analytical framework to Second Amendment claims, as many courts now hold, there's a strong historical tradition of disarming groups that the legislature deems to be dangerous. And Tennessee's law fits comfortably within that historical tradition. So under either of these approaches, this court should reject the defendant's facial and as applied constitutional challenges. And I want to start with the facial challenge. To succeed on a facial challenge, the defendant has the burden to show that the law would be unconstitutional in all its applications, that there are no set of circumstances under which the law would be valid. And so again, the first way that this court can rule in our favor is to say that Heller established a conclusive presumption that felon in possession laws are constitutional. That was one of the basis of the trial court's ruling below, citing to Judge Davis's concurring opinion in the Sixth Circuit's decision in Williams. And certainly we've acknowledged several courts across the country have continued to treat that statement in Heller as a conclusive presumption that lower courts are bound by. And if this court agrees with that approach, it could write a very short opinion citing back to Heller and not conducting the type of historical analysis we've provided. And because this is an evolving area of law, after Bruin, courts are really grappling with these issues and struggling to know what the best approach is. So you have some courts following that approach where they'll just rely on Heller and the presumption of lawfulness. You've also got other courts like the Sixth Circuit and others that have decided we need to conduct this historical inquiry to decide what are the contours of the Second Amendment right as applied to felon in possession laws. And every court that I have found that has considered a facial challenge to felon in possession laws has upheld them. And I don't think the defendant was able to cite a single case facially invalidating one of these felon in possession laws. There's a smattering of cases where courts have held as applied challenges successful to like a purely nonviolent crime like mail fraud, or there's been a recent Fifth Circuit decision where there was a person who was convicted of being an unlawful user or addicted to a controlled substance, and that was an as-applied challenge that was held to be unconstitutional. The Supreme Court actually took that up, indicating possibly they're going to reverse even that decision. But across the board, courts are holding that there is a strong historical tradition of disarming groups that are dangerous. And I do want to clarify one part about this that didn't make it into my brief. Courts that apply the historical analysis and are looking at this tradition of disarming dangerous people, they've kind of split into two different camps. Some courts treat that as permission for the legislature to just categorically disarm a certain group of people on a class-wide basis, citing to these statutes, some of which we've talked about disarming political opponents, religious minorities, and things like that. And some courts look at those laws and say, okay, that's evidence that there can be these categorical determinations that a group of people are dangerous. Now, some of those laws might pose equal protection concerns and due process concerns under other constitutional provisions, but for Second Amendment purposes, those courts will say, yep, you can just categorically disarm groups of people. Other courts, like the Sixth Circuit, have said, yes, there is this historical tradition of disarming dangerous groups of people, but only if they also have an opportunity to contest their dangerousness, so that we're making sort of an individualized determination of dangerousness. And there is sort of a split of authority on that issue about whether the defendant should have that opportunity to make an individualized showing that he's not dangerous or no longer dangerous. And we've actually advocated for that narrower approach, the more conservative position relying on the Sixth Circuit's decision in Williams. But if this court disagrees with our understanding of the history, certainly there are other courts that have treated it just more categorically and not gone into whether a particular defendant would be dangerous.
And even if we followed the Williams approach in this case, though, we know the defendant testified, and he basically just said, I'm not a violent criminal, but here's my history. Is that enough?
No, Your Honor. And under the Williams approach and in courts that follow that approach, they put the burden on the defendant to establish that he's no longer dangerous. He put on no proof other than that one page of testimony, essentially, at the motion to dismiss hearing. And I believe defense counsel just asked him at that hearing, have you ever been convicted of a violent crime? And he said no, in just kind of a vague sense. And then he was asked follow-up questions, so you've never been convicted of murder or rape or things like that, and he just said no. But our position is that's insufficient to carry his burden of showing that he's no longer dangerous. There's no proof of his rehabilitation. There's no proof of the circumstances of the prior drug felonies.
I think you pointed out in your brief that, I mean, we have laws now that one can be convicted of second-degree murder if they sell a drug that causes the death of someone, and we're seeing those cases.
Exactly, and the legislature has explicitly labeled these types of drug felonies as dangerous felonies for purposes of the carrying a firearm with the intent to go armed during a dangerous felony statute. So there's certainly a legislative policy determination that drug felonies are dangerous. They raise a substantial risk of danger even if they don't require an element of the use of violence. We also have the defendant's prior convictions that are in this record. So the only evidence in the record would suggest that he is still dangerous. And I want to push back on defense counsel's argument that this is somehow a problem because it would be a judicial determination rather than a jury finding. So if you look back at these historical statutes that courts have relied upon to identify a historical tradition of disarming dangerous people, as the Sixth Circuit noted, a lot of those statutes would have carve-outs that would allow those groups of people to regain their gun rights if they were able to demonstrate they weren't dangerous, such as by taking a loyalty oath, for instance. If you were, a loyalist or a minority of some kind, to show that you weren't dangerous. Other statutes required you to bring, 5 witnesses who could attest that you were a peaceable person, and things like that. And most of those decisions were made by a local justice of the peace who was making that individualized determination of dangerousness. It was a judicial officer. It wasn't a jury question. So this is consistent with that historical tradition of disarming dangerous people. If you agree that they're entitled to an individualized determination, there's a tradition of that determination being made by a judicial officer. And I acknowledge, as my friend has stated, that our statute doesn't have those statutory carve-outs, and it doesn't create sort of an administrative process for making and raising these types of dangerousness claims. But we do have, as Judge Holloway mentioned, we have a separate statutory regime with the Restoration of Rights Act that explicitly allows convicted criminals to come in, to be proactive, instead of just violating the law and hoping they don't get caught, to come in and petition for the restoration of their rights. And certain drug felonies actually you can get expunged under that statute, which is another reason why this is not facially unconstitutional, because at least for as applied to those offenses, you could get it expunged and it wouldn't be a permanent disarmament. But even for drug felons like Mr. Russell, who wouldn't qualify for expungement, they could still come into court, file that petition for restoration of rights, and say that statute, which is disarming me, is unconstitutional as applied to me because I'm no longer dangerous. Maybe it's been 70 years since you were convicted of this offense, and there's no reasonable.
So there is a process for drug offenses that are not expunged to still have that individual's rights restored to bear arms.
For certain drug offenses, yes. I don't think the statute, there's an exclusion for certain felony drug offenders, like this case. But for lesser drug offenses, the expungement statute does not exclude all of them.
What drug was involved in this case?
In this case?
Mm-hmm.
So this case was not a drug case.
I'm
because it was
sorry,
a-
yeah. I
there
guess it
were
would have been
several
what he was
prior-
conviction of. Do you
Yeah.
know what the drugs were that he
There
was?
was a sale of cocaine,
Cocaine.
possession with intent to sell of methamphetamine,
Meth.
and then conspiracy to sell cocaine, I
Okay.
believe.
And those would be types of offenses that you could not get your rights restored for.
I don't believe so. And I think this court's interpreted our expungement statute to limit you to like one felony expungement. And so he has 3. So he wouldn't be eligible to get all of them expunged under either way. But what he could do, though, is petition for that and bring an as-applied constitutional challenge, which would be analogous to these historical statutes where that would allow you an opportunity to show, I'm loyal to the government and I'm not a danger to society. And that's how the Sixth Circuit addressed it. It said you don't have to have a statutory carve-out. You can also have availability to bring as-applied challenges. And again, that's assuming the court agrees with us that you're even entitled to that individualized determination. I mean, some courts just say you're not and say the legislature can just categorically disarm groups of people. I also want to clarify, just historically speaking, this statute has been on the books, at least in some sense, for 50 years. I know there was some discussion about this in my brief and in the reply brief, but we cited the Public Act. It's 1976, Tennessee Public Acts, Chapter 793. And I just double-checked when I read the defendant's reply brief to make sure I didn't miscite it. And I pulled the statute from our library and scanned it in. It says, an act to make possession of firearms, destructive devices, and dangerous weapons a felony under certain circumstances. And it specifically mentions any person who's been convicted of violating Tennessee Code Annotated Section 52-1432, which is the Drug Control Act of 1971. So in some shape or form, we have disarmed convicted drug felons since 1976. As far as I'm aware, there's never been a constitutional challenge to that statute or its successor statutes. And again, I'm not aware of any successful facial challenge to a drug felon statute across the country. And I also wanted to mention some other opportunities the defendant might have to bring this type of as-applied challenge to contest dangerousness. You could bring a declaratory judgment action as well. We cited the Blackwell decision, which was actually an example of someone who had been convicted of a prior felony who wanted to be able to carry arms and filed a declaratory judgment action to get his rights adjudicated. It was a little bit different. It wasn't a Second Amendment claim. It was a full faith and credit clause claim. But that shows another example of how you could do that. And I also wanted to clarify our reliance on Blackwell, too, because we have some other litigation that I didn't want to be speaking out of both sides of my mouth. Our position would be that you would need to file that declaratory judgment action in circuit court or criminal, or if it's in criminal court, bringing it as a defense. But I don't think a chancery court would have jurisdiction to declare a criminal statute unconstitutional. And of course, as here, you could also raise it in defense in your criminal prosecution, but preferably someone that really wanted to be able to carry firearms as a convicted drug felon would be proactive and use some of these other civil mechanisms to adjudicate that.
What's the state's position after Bruin, Heller's language that these laws are presumptively okay, constitutional. What's the state's position on that?
Yeah, it's hard because courts have come out differently on this. So we obviously erred on the side of caution by engaging in the historical analysis that Bruin requires, and I think that's probably the best approach to take. Heller didn't have felon in possession laws at issue in the case, so it wasn't necessarily part of the holding. But we also have language from the Supreme Court, and even in our state courts, where lower courts don't lightly just disregard statements by higher courts, and sometimes the higher courts don't appreciate characterizing certain things as dicta, but that can sometimes be a case-by-case determination. So we'd be happy for the court to engage in the Bruin-style analysis, but it's ultimately this court's decision as to how to correctly apply the law. We just wanted to put forth the different paths that this court could take. I also wrote down, Judge Holloway, you were asking about the law-abiding language in Bruin, and I actually do agree with my friend on the other side a little bit about Rahimi walking back that language. And when you go back and read Rahimi, which is post-Bruin, they clarify that they did not intend the law-abiding language to be speaking about who constitutes part of the people for purposes of the Second Amendment. So our position is not, and this may have been argued a little bit differently in the trial court, but on appeal, our position is not that felons are not part of the people. We're really relying more on the historical tradition of disarming dangerous people who were not law-abiding. So I think the law-abiding language is still doing a little bit of work for us there. It's just a little bit of a different spin. Whereas before Rahimi, there were litigants who were trying to argue that you're not part of the people if you were not law-abiding. But really, the law-abiding part goes more towards the dangerousness inquiry. So I just wanted to clarify that as well. Looking over my notes to make sure I haven't missed anything that I wanted to say. I think I've covered everything that I wanted to cover, so unless this court has further questions, we ask you to respectfully affirm the judgment of the trial court.
Thank you. Mr. Justice.
With regard to this language from Heller that laws barring felons from owning firearms are presumptively constitutional, the fact of the matter is that case was not talking about laws barring felons from owning firearms. And there's plenty of case law from courts in Tennessee and everywhere saying, in effect, all laws are presumptively constitutional. And what that means is we presume that they're constitutional until they're challenged. And so at minimum, it's fair game to challenge the law, but beyond that, Bruin goes further, and it actually flips the presumption the other way. Bruin basically says any laws that restrict any of the people from keeping or bearing arms, they're presumed unconstitutional. And the only way to overcome that presumption is for the state to come forward with specific examples from the 1700s, early 1800s, showing that we did similar types of things back then.
So are you saying you disagree with the Williams approach from the Sixth Circuit?
I do disagree with the Williams approach, Your Honor, and for the main reasons I've already stated. One, there's not any examples from the 1700s of barring even dangerous felons from owning firearms, whether they're smugglers or whatever else. Two, our law doesn't specify that you have to even be dangerous, and so we're writing additional language into the law that's not there, violating the separation of powers. Two, the state's proposal and the Williams proposal violates your right to a jury. And three, it violates due process by making you have to come forward and convince someone, whether it's a jury or a judge, that you're innocent, instead of having the state prove you guilty. And so I do disagree. Williams is maybe a step in the right direction, but it's a very small step, and it doesn't go near far enough in fixing Second Amendment problems.
Is there any state that has basically taken your approach and found these laws restricting drug felons from possessing weapons unconstitutional?
I'm not aware of a state that has done that, Your Honor. My understanding is I think the Third Circuit has said that nonviolent felons do have a right to it. I don't know that they go specifically as far as saying drug felons, even though drug felons are nonviolent. But if it's,
Are you saying all drug felons are nonviolent?
well, if all you have is a drug, if all you've done is a drug felony, I would say that's nonviolent. Yes, yes, Your Honor.
Even though drugs, the sale of drugs that result in someone's death is now
If you've done,
second-degree murder in this state.
if you've sold drugs and you've gone further and sold bad drugs that kill someone, then that could maybe be considered a violent crime. Yes, Your Honor. I do agree. But Mr. Russell hasn't had that problem. The basic problem here is the state has not pointed to or even tried to point to any examples where the American government tried to disarm any part of what was considered the people. Slaves, not really considered part of the people. Even freed blacks, they weren't really treated all that properly back then, even when they were free, not fully part of the people. The people would be, you know, people from England, people from Scotland, people from Ireland. Catholics, again, not fully considered part of the people, and that was codified in English law at the time. And so the state has not pointed to any examples where someone who is part of the people, like Mr. Russell, was disarmed. They haven't pointed to any laws from that time about barring felons from owning firearms. They simply have not satisfied the test of Bruin. So I would ask that Your Honors find that the court has erred, that this law does violate the Second Amendment, and that you reverse and dismiss the indictment.
Thank you both for your arguments and your briefs. Do y'all need a break, or are you good?
I'm good.
You good? Keep going?
It's up to you.
Okay. If you'll call our next case, please.
State of Tennessee versus Miracle,